I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we're jumping into number 167 on our compilation list. This compilation will feature 3 different judges, but we have a theme on this compilation, and that is sovereign citizens who don't like to pay their bills and that try to use the sovereign citizen script to get out of it. So we will be featuring 3 of those sovereign citizens in 3 different courtrooms once again. Before I give you the rundown of those courtrooms, just know commentary will be left in from some of these previous proceedings. Also, chapters will be added for your convenience. And now, let me give you the name of those judges, courtrooms that we will be in on today. First, we will be in the courtroom of Judge Sheila Martin out of the state of Michigan. Second, we will be in the courtroom of Judge Simpson, also out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Gary Bashor out of the state of Washington. Guys, thank you for riding on this train with me through this compilation land. And it's about that time to jump into 167.
Who's participating by phone?
On and for the record, I'm Houston LaShawn DeYoung, more beneficiary. I'm here in my proper person.
What's your first name?
My first name is LaShawn DeYoung. My surname is Houston.
All right.
I'm here in my proper person, my own right, and haven't reached the age of majority. I'm a Moore Aboriginal, America's Aboriginal, Illinois national.
Is
but
Kimberly,
not a citizen of the United States.
is Kimberly available?
Not a citizen of the United States.
Is Kimberly
Or
available?
the United States for the District of Columbia. Houston Kimberly Denise is deceased. I am the sole beneficiary and real party of interest in this matter.
All right, just a moment. Before the court this morning is the landlord's complaint to recover possession of property. The person entitled to possession of the property is the plaintiff due to a sheriff's deed of redemption.
I object.
A sheriff's
and deny.
deed. Ma'am, please don't interrupt. I'm reading.
Not a ma'am.
Graph.
Excuse me. I'm a male.
Okay.
I object and
Sir.
deny.
Sir, please don't interrupt. I'm reading from paragraph.
You're trying to put something on the record has not been proven.
I'm going to have to
I
mute
object and
you
deny.
if you continue to interrupt the court.
If you mute me, then you are violating my rights. You haven't even proven you have jurisdiction over this matter. You haven't proven you have
Judges don't
jurisdiction
prove
or
things.
subject matter jurisdiction.
Judges don't
Excuse
prove
me?
things. Parties
Don't
prove
prove
things.
things.
That's correct.
No, the court has to prove that it has subject matter jurisdiction and personal jurisdiction over the subject matter.
You are now being
You
muted.
don't have to prove that.
Officer Denham. Thank you. As I was indicating, the complaint to recover possession of property received by the court on October 25th of this year and signed by plaintiff's attorney who was present on the record indicates in paragraph 5F that the plaintiff has a right to possession of the property because of a sheriff's deed and the redemption period expired on September 8th, 2022. Is that correct, counsel?
That is, Judge, and the court will note on the complaint, we actually attached a copy of the sheriff's deed too. I believe it's the next document under the actual complaint.
Yes. So can you give me the history of the tenancy?
Yeah, can I do it informally, Judge, without having my client sworn, or does Your Honor want it to come from my client directly?
Anything that he says is impermissible and it's prejudicial. Statements of counsel in argument or in brief are insufficient for granting of a summary judgment or dismissal.
Your objection is over.
Matter. He is a third party in this matter. I want my objection on the record.
Your objection is on the record.
Time.
Your objection is on the record and your objection is
anything
overruled. You're again being muted.
Is a third party.
I need her muted or him muted. Thank you.
Anything that is said scandalous and prejudicial and a
I am
destruction of my rights.
removing Mr. Houston from the hearing because of continual interjections, interrupting the court's proceedings. I will later consider whether to find him in contempt of court.
Judge, I removed his Chan's ability to unmute himself if you want to.
Thank you. That'll be fine.
Yeah, he can't unmute himself anymore.
All right. Okay, counsel, what I was asking for is basically when the tenant took possession and the historical facts as to the sheriff's deed and the redemption period.
All right, Judge. So the way, and I can have my client sworn in to identify for the court the specific.
Oh, sure.
facts. The actual scenario is the homeowner, which I believe are the Houstons, were residing there, and they had a mortgage. The mortgage fell into to default, and the property was placed. For foreclosure, and it went to a sheriff's sale. And my client was a successful.
It went into default on the mortgage or on the tax bill?
On the mortgage, Judge.
Okay, and who held the mortgage?
Genesis it's Genesis Credit Union as reflected in the sheriff's deed.
All right.
And my client, when it was put up for public auction, my client actually was the highest bidder, concluded that transaction through Oakland County, and then the sheriff's deed on the mortgage sale was issued and then ultimately recorded after the 6-month period of time. So we're here today. No, there's been no participation, and the court will note, I mean, you heard a little bit this morning on the record, which is why you muted the defendant. There were some documents filed in this matter by Mr. Houston, and if the court has read them, that's great. But it's pretty much it's the kind of things that he's saying, nobody has jurisdiction over him. You can't take away the property and whatever. Bottom line is he had a mortgage, went into default. We were the successful bidder at the sheriff's sale. 6-month period of redemption has passed. No payments were made, and we want to take possession.
Okay, thank you. Mr. Houston, I have a question for you, and that is whether within the 6-month redemption period, you did anything to redeem the property. Officer Denham, we need Mr. Houston unmuted.
Mm-hmm.
I've entered onto the record in that first case that third party was just talking about, proof that mortgage has been discharged by Genesis Credit Union. And it was discharged before October. It was actually discharged in July.
What do you mean by discharged?
It was discharged. The mortgage is paid in full, discharged. And it was entered into the record of the first case.
I have
Before
several
the redemption
filings.
period was even over.
Did you file
Before
that?
The redemption period was over. I didn't file it over. I filed it in the first case. It's still evidence in that first case that he referenced.
One moment. Attorney Hirschfuss, am I saying it right? Hirschfuss.
I still object to him even speaking in this matter. He's a third party intervener.
He's going to speak. That's my decision.
Everything that he
Please
said
don't
is
interrupt.
scandalous and
okay, you're muted again.
Prejudicial.
Sir, did you obtain a copy of the original file?
No. Let me just indicate for the court what the discharge he speaks of.
Yes.
The Genesis discharged the mortgage because we paid it off. So there is by the way, it's not a discharge, it's called a satisfaction of mortgage.
Yes.
And it's dated on May the 24th, 2022, and recorded in Oakland County Register of Deeds office on June 2nd, 2022.
All right. I have not yet adjourned it to continue, sir, but go ahead. You were going to read the discharge.
It says satisfaction of mortgage. Know all men by these presents that Genesis Credit Union of Auburn Hills does hereby certify that a certain mortgage dated May 3rd, 2018, made and executed by LaShawn Leon Houston and Kimberly B. Houston, husband and wife, to Genesis Credit Union and recorded in the Register of Deeds office for the County of Oakland, Michigan. The lot and everything, the tax parcel and all that is fully paid, satisfied, and hereby discharged as of today's date, 5/24/2022.
Thank you. And that is the same document that the attorney for the owner has read into the record, sir. And so he's indicated that it's his client, Mr. or Shepherd Properties LLC, who satisfied that mortgage by paying it off. In what amount, sir? In what amount, Mr.?
Judge, a deed or bond found with the debtor is presumed to be paid. He has no mortgage with his name on it. He has no proof that he's an adverse party or that he's a bona fide party to this matter. He has no proof that he gave any consideration to the sheriff, and the sheriff gave any consideration to me in order to sell my private property in the first place, which is actually owned by a trust, and the Oakland County Register of Deeds and the Oakland County Treasurer has been notice of that property has been transferred into trust as of 2021. So at what point in time did the sheriff give consideration to me or my trust for my property in order to sell it in the first place?
Sir, you would have to consult an attorney about that process.
I don't need to
However,
speak to an attorney. I'm here my own proper person in my own right. I'm suing you this. I don't need no attorney. He's no guardian over me. I'm not a minor.
all right, thank you.
Now, furthermore,
You're going to be muted now in order for me to address
Can I have
some
your
of what
name?
you,
Can I have your name, please?
my name should be on the screen, or you're on the phone.
I
It's-
don't have the screen open. I'm on a telephone. Can I have your name, please?
Yes, when I'm ready
The
to
name
give it
can't
to
speak.
you. When I'm ready to give it to you. Please mute Mr. Houston so that I can address his issues. All right, so we will adjourn this until, or continue it on January 18th, 2023 in the afternoon. The docket time will be stated on the notice of hearing that is mailed to the parties and counsel.
Very good, Judge.
And the
Um,
reason for the continuance is for the plaintiff to present the satisfaction and the recorded deed. And Mr. Houston, my name is Judge Sheila Miller Martin. All right, we can unmute Mr. Houston before closing for today.
Could you repeat that, please? Repeat that,
Right.
please. You said Sheila Miller Martin.
That's correct.
Have you taken an oath to uphold the Constitution, Judge?
Sir, I don't answer those types of questions. I'm not a
Have you
witness
taken
or a
an
party.
oath? Have you taken an oath? That is a question for you, Judge. All you
Goodbye.
have to do is say you've taken an oath.
Peninsula Place versus Trellis Lane.
Lawrence Kreffman for the plaintiff, Your Honor.
Hey, Jan, how you doing?
Okay, I'm doing okay. How are you doing?
I'm doing well. Yana, can I get sworn in?
No.
You said no.
Yes, that two-letter. Mr. Kreffman, how much is owing on this account?
Your Honor, the rent to retain possession is $1,978.19, plus court costs of $161 for a total of $2,131.19.
Sir, how do you intend upon getting that paid?
Your Honor, I am the first-hand witness. I have certain facts obtained a matter of hand. I am the beneficiary of my estate. I am the taxpayer. I am the signed person by the Social Security Administration. That card is in my name. I don't know if you got any of my emails.
No, I got them all.
And I also sent a I sent the hard copy to the court. I don't know if it was have time to get there. It should arrive at 10:30. Like I was stating, I want to have a motion to be on behalf of the plaintiff. I've shown all proof that I have an interest and ownership on this account, and I've been performing, and they have not been accepting my payments.
They haven't been accepting your payments?
They have not. I sent the letters.
How much did you send it in U.S. currency?
I sent them by my endorsement.
Okay, that wasn't my question. My question was, are you sending it in U.S. currency?
No, Your Honor, we don't have currency. All we have is credit.
I see. Okay, so here's what I'm going to do. When's my trial? Let me see. When can I send it?
You want to do a trial?
Yes. Yeah. Or whatever. Every day I got.
Do you want to do it on the 3rd since we're on?
At what time? No, because those other people will be here.
Oh, okay.
Just give me a date.
Monday the 9th at 1:30.
All right, real good. So here's what I'm going to do. So just skip the formalities. I'm going to set this for non-jury trial Monday, January 9th, 2023 at what time?
1:30.
At 1:30. That will be that will be in person.
Okay. Thank you, Your Honor.
Mm-hmm.
Thank you, Your Honor.
Thank you.
Bye-bye. Happy holidays.
Yes, and to you, sir.
Alrighty.
Court does call the case. Peninsula Place versus, is it Trellis Lane? Here.
Good afternoon, Your Honor. David Van here on behalf of the plaintiff.
Sir, your name?
Sorry, Judge. Trellis Lane.
All right. This is the date for non-jury trial, and this is a non-payment of rent case. How much is the plaintiff claim is owing?
Your Honor, the total balance at this time is $3,320.17 plus court costs of $161.
3,000. I'm sorry. 3,000.
$3,320.17.
All right.
Hey, Your Honor.
Sir, of that amount, is there any that you believe that you owe?
No.
You were going to say something.
I was going to ask to object what he was about to say as far as about the numbers. About saying what I owe, but you already answered the question. I mean, ask me the question.
And
I
Mr.
can break down that amount if you want me to, Your Honor.
Pardon?
I can break down the amount if you'd like me to.
Just one moment. We'll get to that. Sir, can I ask you, I received the documents from you. Is there a reason why you don't think you owe that amount?
Because it's already been paid, Your Honor. Far as reporting adverse information about a co-signer Act 211 of 1989. Peninsula Place is trying to held me liable as the co-signer when I have an interest and a signature and I'm a natural person. So they're trying to hold liable.
Okay, so let me ask you this.
Okay.
Just so that I have the background on it. You reside in this unit that's at I think 315B.
Correct.
At 1000. You reside there.
That's my place of abode.
Well, you live there, right?
Depends on who you're talking about. I'm acting as a consumer. So far as like my I'm there on special appearance and my estate stays there. But as far as a natural man, I don't have no place. As far as my estate and my
Okay, so when whoever is in this courtroom leaves here to go to what they would call home, where does this person that's sitting here go?
To my place of abode, Your Honor.
Which is where?
Plymouth place.
Okay, at the 315B.
Correct.
All right, that's what I need to know. Okay. Do you have a ledger?
And I'll give Mr. Lane a copy also.
Thank you.
And Mr. Fantera, this would be your witness, is
Yes.
that correct? Okay, why don't we do this? Why don't we have her and Mr. Lane sworn in, please?
Thank you.
Yeah, what is it?
Right hand. Swear affirm the testimony you're about to give. Okay.
I do.
Raise your right hand. Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your Honor, could I give you real quick context on that?
Yes, please.
We had a previous case last summer where Mr. Lane received Sarah funds. And when we had I have a case number, I have a copy of the unsigned copy of the COD. That was entered on September 9th. SOS paid his rent through September, and it left a small balance of, I think about $119, which we waived. So the balance, even though it doesn't show it on there because we didn't actually get the SOS check till sometime later, his rent at the end of September was $0.
Got it.
So the total balance that's on there is 5 months of rent at $513, water and sewer bills, electric bills. There's not even any late fees. And then there's 161 in court costs. So I just wanted to clarify that, in fact, none of this goes back past September 30th. In fact, I don't know if you remember, we actually, when we had the previous case, Mr. Lane had sued Peninsula Place seeking the return of all money he paid forever. And he denied that he owed money, but simultaneously applied for Sarah, and he denied he applied for Sarah. You verified with probably Aaron at the time that he had applied for Sarah. He ended up getting Sarah funds. He would not sign the COD, and then you basically gave him a choice. I'll enter the COD, or we'll have a trial and I'll give you a judgment. But it sounds like he's raising some of the same stuff now that he attempted to raise.
Your Honor, free to speak.
Go ahead, sir.
So, Your Honor, when I applied at first I didn't know what I was applying for. So when I applied for Sarah funding, I ended up giving my principal information, which was my name, my date of birth, and my social security number. Basically, I'm here today saying that I gave my principal to Peninsula Place and I've never received any consideration.
Your Honor, I don't understand what that means.
I don't know what that means. However, are you Trellis Lane? That's a yes or no. Because I'll tell you, if you are, then we'll go ahead with the trial. If you're not Trellis Lane, then I'm going to give them a judgment by default because Trellis Lane hasn't shown.
I'm here on special appearance.
No, you can't do that. You are not an attorney at law because you can't appear for somebody else. So my question is, and I'll ask it again, are you Trellis Lane?
Yes, Your Honor.
Thank you. So, Mr. Lane, October of 2022, did you pay rent to the landlord?
Yes, Your Honor.
Okay, and how did you pay that?
I'm paying with my credits that's on file. So I sent instructions back in May, basically to get my account zero every month.
To do what?
I sent instructions back in May, then I sent another one to December to the CEO.
The CEO of what?
American Campus Communities. Saying right. So he's seen my email, so he's aware of what's going on. Basically, like I say, I'm looking for consideration. I have not been getting no consideration, no adequate consideration.
Well, you get adequate consideration for the contract and any payment by virtue of the fact that you have a residence. So I don't think consideration is even an issue.
But Your Honor, I have several questions.
Well, you can go ahead and ask your questions, but I don't know. Let me just ask this. October 2022, how did you pay your rent?
I paid with my took the bill, I endorsed it.
Did you give them cash?
We don't have,
We being whom?
I'm saying, it's a credit system, Your Honor.
It's a what?
Credit system. We don't.
So who's in charge of this credit system?
You said who's in charge?
Surely.
I mean, we haven't had money since 1933, the American Bacon Act.
We being whom?
As
Who are you talking about when you say we haven't had money? Who is we?
far as like the United States haven't had money since 19.
Oh, they definitely have, and I spent my share. So I don't know. You're saying you gave them credit.
Yes.
In what form did you give them credit in the month of October 2022?
Then credit, I took the bill, which they give me a bill every month, which is a statement. I take the statement. If you want to, I can show you what I'm doing.
I know what he's referring to. Can I show you?
Yeah.
Well, show him, and then
I got copies for him. Here's what he's getting, Your Honor. We have a third-party billing company called Zigo. And so what they do is every month they bill the utilities. So he gets this bill, and then you'll see at the bottom what he writes is pay to the order of Peninsula Place. And so what he's taken, so for example, the top one says pay to the order of Peninsula Place, $662.12. That amount is his monthly rent plus the $123.12 in utilities that are at the top. There's 3 of these that I've attacked. So what he does is he cuts off the bottom and he mails that in as with instructions to pay to the order of Peninsula Place as if that's a check.
have this marked as plaintiff's exhibit and 2. The ledger being 1. But Mr. Lane, you have a copy of what I've marked as plaintiff's exhibit 2. Is what Mr. Fantera described, is that correct? Is that what you do?
Yes, I'm accepting the credits that's given to me and I'm transferring to that.
Who's giving you this credit? They who?
So Peninsula Place, so in the beginning, when I signed up with Peninsula Place, I gave my principal information. So those payments are supposed to come to me as credit. So
what payments?
The payments that's coming every month. So those payments, they're trying to hold me liable for it, and I'm taking the credits that I'm receiving and dishing it back to them, to Peninsula Place.
Who's giving you credit?
You said who's giving me credit?
Yeah.
I have credit, Your Honor. I have a security interest.
In what?
And this so-called contract with Peninsula Place.
Okay, but who's giving you credit? Young man, you keep using these terms, payment, credit, and it seems to me as I'm listening to you that you're using them improperly. So my question is, have you paid anything to the plaintiff in US dollars or anything that evidences US dollars?
No, I haven't paid in US dollars.
Or anything evidencing US dollars, like a check, credit card, anything like that.
So this is...
No, that's a yes or no.
Can you repeat the question, Your Honor?
Have you, let me just break it apart so we get it real clear. Have you paid for the months of October 2022, November 2022, December 2022, January 2023, or February of 2023? Have you paid to anything to Peninsular Place in US dollars?
No, Your Honor.
Have you paid anything to them that is evidence of an account which holds US dollars?
Yes, Your Honor.
What? And what account is it attached to? You better be careful about answering my question. Because if you're telling me that you gave them or paid them something that evidences an account that can access US dollars, show it to me.
You said that's access to US dollars? Right here.
What is that? What Mr. Fantera just gave?
Yes,
How does that access US dollars?
because Your Honor, this account, I'm the holder and I have the interest.
Then show me the balance on that account.
They show you the balance?
Yep.
It shows you the balance.
No, you haven't shown me anything. Show me the balance on the account. If you give somebody something that evidences that they can access US dollars, then there is a balance on that account in terms of what you're giving them. Much as if somebody gave a check to them, they would be able to show the account for which they can then present that check and receive US dollars. Show me that account, Mr. Lane.
Like I said, Your Honor, I don't know what else you're asking for. This is the.
No, you know exactly what I'm asking for.
You're asking for something that's coming out.
Something that evidences that by that piece of paper that you've given them, that they can access US dollars.
Okay, I don't have any other account besides this, Your Honor.
You don't have any what?
I said I don't have any other evidence besides this right here.
That does not show me that they can access US dollars.
Okay.
Where would they take that to, in your mind? Where would they take that to access the United States dollars?
Put it on the ledger.
Where would they take it to access US dollars?
So, okay. So, Your Honor, so I got a question. As far as landlord and tenant relations, relationships, it's sitting here.
I'll try to answer your question as soon as you answer mine.
Okay.
Where would they take it to access US dollars?
They would take it and take the check and put it on the ledger with my credit. Because if I owe something, Your Honor, it would be in a negative balance. How can I pay something that's in a positive balance? How can
You don't have a positive balance.
this is
You have given them a piece of paper that you yourself just said is a check. So where would they take that to access your account
so, Your Honor,
and receive US dollars?
they're acting in dishonor. They're taking it and they never said anything about or object to it. So it was off.
Oh, they're objecting now, certainly. Where would they take it, Mr. Lane?
So where would they take it? I mean, as far as they have a security deposit deposition bond. So they have it in a financial institution.
What financial institution
I'm not.
would they take it to get cash from your check, as you call it, that would then be debited from your account? Where would they take it?
Debited. So what about the credits, Your Honor?
I don't see a credit.
On this paper, it says credit payments and credits.
That's not what it means, to the extent it says that. You have no credit. Where would they take it to get US dollars?
So where would they take it? They would take it out of my trust, Your Honor.
Out of your trust.
Yes.
Where is this trust located?
We all have a trust in
Okay, let's say we all do. I'm not accepting your premise, but let's say we all do. Where is your trust located?
I'm not sure where it's located, Your Honor, but
So if they wanted US dollars for this thing you purport to be a check, you can't tell them where to take it.
in the Treasury,
Which treasury?
the Treasury,
Oh, so they have to go to the US Treasury with this thing that purports to be a check. Really?
they was pulling from the Treasury. That's why they asked for my information.
Who is pulling from the treasury?
Peninsula Place, Your Honor.
So Peninsula Place is pulling from the US Treasury.
I got the account attached to my name with my social and my information.
So they're pulling from the US Treasury because of that?
Say that again?
So because of that, they're pulling from the US Treasury?
I mean, they're charging the account. So this account has my information tied into it, which is showing that it's already prepaid. So what they're trying to do is Peninsula is trying to make me repay.
You've never paid anything. So they're not trying to make you repay. They're trying to make you pay.
Your Honor, so how did we get here if I never if I provided my information to Peninsula Place?
We got here because you have never provided them anything
Okay.
to pay on this account in US dollars or anything evidencing US dollars. That's how we're here for 5 months. You haven't done that.
Okay. So in the contract, it says payment and then specify what type of payment.
I'm asking you, have you paid them in US dollars?
No, payment credit.
But you have no credit.
Your Honor, this is evidence.
Hold on.
Okay.
In order to pay in credit, if you will, you must have something that evidences a balance on that credit. I've already asked you once. Why not? I'll ask you again. Show me something that evidences the credit.
That shows the credit, the birth certificate, and a social security number showing my line of credit that I applied.
So how much is in that line of credit?
You say how much is in the line of credit?
Sure. If you got a line of credit, it's got to have a value. So how much is in it?
I believe everybody has $1 billion.
I didn't ask everybody. I'm asking how much is in your line of credit?
Well, with Peninsula Place, whatever.
No, I'm asking you. You're saying that your birth certificate and the social security, you have a line of credit. I don't believe that to be the case, but what the heck? Let's ask you, how much is then in your line of credit?
Not sure, Your Honor.
So if you're not sure how much is in there, and you give them this thing that evidences, as you're saying, just take this 1 month of $662.12, you don't know if that can be subtracted from that credit you supposedly have.
I'm believing at least $1 billion worth of credit, Your Honor.
Oh, you have $1 billion worth of credit.
We all have credit, Your Honor.
Well, I'm not worried at this point about anybody else's credit. I'm worried about yours. You're saying you have $1 billion, but you have nothing that shows me that you have $1 billion worth of credit. Mr. Lane, plaintiff is claiming that you owe them $3,320.17. Tell me every reason why I should not give them a judgment for that amount.
That's going against Michigan Consumer Protection Act.
What particular provision are you claiming of the Michigan Consumer Protection Act?
Enter into a consumer transaction in which the consumer waives or purports to waive right, benefit, or immunity provided by law, unless a waiver in clearly state and the consumer has specified consent to it. I never gave no consent.
What have they asked you to waive?
You said where they asked me to waive my rights.
To
as a
what?
consumer.
As a consumer of what?
You said a consumer of what?
Yeah.
Of this Contract,
What rights did they ask you to waive?
my interest.
What interest?
I have an interest in this so-called contract.
Oh, you do. You also have certain obligations under that contract.
So I have obligations.
Oh, yeah,
Okay.
like payment.
Okay. According to, like I said, landlord and tenant relationship, pay the landlord for all the rent arranged under this rental agreement. And that's basically what I have the security deposit for.
No, your security deposit is not under Michigan law for that reason.
What is for, Your Honor? That's what it says, security deposit permissible uses.
And there is no security deposit under this lease. They do not require a security deposit. It's zero.
Okay. Even worse.
Under which
You don't have a security deposit.
Your security deposit is zero. You did not pay a security deposit when you moved in. This client does not require.
you say move in, all this from where?
And even if you had one, the Security Deposit Act, you can't apply it.
Sorry.
So what other reason do you have why you don't owe this money?
And what other reason?
Yeah, you told me Landlord-Tenant Relationship Act, which you haven't pointed to a particular provision. You talked about a security deposit of which you have none, so that can't be a reason. I don't know, and you haven't pointed to anything under the Landlord-Tenant Relationship Act that would even be applicable in this particular case regarding the monies that you owe. You cited the Michigan Consumer Protection Act. There's been no benefit that they've denied you, no interest that they've denied you. So that can't apply. Give me anything else as to why you don't owe this.
Anything else why I don't owe? I don't understand what else that you're looking for. Like I said,
I want you to tell me every reason why I should not say and give them a judgment for this, the $3,320.17 plus their cost.
so Your Honor, I'm sorry, can you repeat that again?
Which part?
You're saying, so how is this not like a contract of adhesion that is more beneficial to Peninsula Place?
I don't know what that meant. Explain what you're trying to say to me.
So it's two parties, and I consider the weaker part. So they wrote this contract and all in the benefit for them. So where did I have any say so in this contract?
Well, you had the big say so of no, you didn't have to sign it.
So ain't that false and misleading? They was never no.
No, that's not false and misleading.
It's supposed
They
to be
didn't.
disclosure.
They didn't force you to sign it. You signed it.
So I'm signing. So is this a loan that I'm getting from Peninsula Place?
No, you are not getting a loan from Peninsula Place.
So,
You are renting an apartment
correct.
in consideration for the use of that apartment, which belongs to Peninsula Place. You're to pay them rent. You haven't for the last 5 months. Actually, you didn't pay it before then because Sarah paid it, but you haven't paid rent for the last 5 months.
Yeah, no, all bills are prepaid.
No, they're not.
Okay.
Your bill is not prepaid.
Like I said, it's in the positive balance. If I owe anything, it will be in the negative.
I don't even know what that means because your positive versus negative is different than anybody else I've ever come across.
You said my positive is.
Yes, right now you're in the negative of about $3,320.17.
Yana, when I log into my portal, it shows a positive balance. I can't owe something in a positive balance. It's just if I log into my app on my mobile device to look at my bank account, it's in a positive balance.
Your bank account.
Yes, this is a positive balance. If I owe anything, it will be.
So you have the money. So you have $3,320.17.
I'm giving an example.
What's giving an example?
If I owe anything, it'll be in the negative.
I don't know what that means. You don't have a credit on this account. You owe them $33.20.17.
If I don't have a credit, Yana, how do they make up an account number with all my information? I had to give them something.
Yeah, you gave them your information. The only thing you haven't done is give them money.
So in other words, you're telling me that I have to repay them, which is already paid.
You never paid it.
Okay.
No matter how many times you keep saying it, you never paid it.
Like I said, Your Honor,
You've never paid anything since October.
I have federal questions.
You have federal questions. Okay, well, you can take those up where they'll hear those. I don't know what federal questions you have because every state question that you attempted to try to raise falls flat on its face. There's no violation of the Michigan Consumer Protection Act. There's no violation of the Truth in Renting Act. You haven't paid anything. You won't show me an account where that even evidences that you have the money. You haven't paid it.
So this account right here doesn't show my name, Your Honor.
You don't have an account. If you're talking about a financial account, you don't have an account. You haven't shown me one. I've asked you for it. You haven't shown it to me.
Like I said, the account is right here, Your Honor.
That's not your account.
So who account is it? It has my name on it.
You keep calling it an account. It is not an account. You'll have a lot of things that will have your name on them. They aren't your account.
They're tied into with me, and I have an interest.
Okay. You can have an interest. You can have all of that. You have nothing where they could go and get cash. Nothing where they could go and get anything that would even remotely represent payment on this account. And you haven't done so for the last 5 months.
So, Your Honor, on this ledger, it say payments credit.
Look, I'm not going to sit up there and go back and forth with you on that. I've asked you just plain out. Tell me every reason why you don't think you owe this money.
So, Your Honor, I'm a responsible party, and I gave my endorsements. They accepted, and I'm demanding payment. They never gave me pay. Like I said, I have my birth certificate, I have the social security number showing that I am
Do you have a bank account?
my bank account. What does the bank account have to do with?
Because that's usually how people pay for their rent.
Your Honor, all I'm doing is enforcing my rights.
I'm not sure which rights you think you're enforcing because I haven't heard one yet. Is there any other reason you believe that you don't owe this 33-20-17 that you have not already stated to me?
Any other reason? No, I don't have any other reason besides, like I said, Your Honor, it's already prepaid. And they're trying to make me pay twice, acting in dishonor, accepting and not returning, not saying anything of it. They're not accepting. So they've been taking it ever since I started, maybe March last year.
Ma'am, your name is Jane, full name?
Jane Hogan.
Miss Hogan. And what is your position with Peninsula Place?
I'm the property general manager.
Okay. And you would be familiar with the books and ledger regarding this particular unit?
Yes.
You had an opportunity to review that prior to coming to court today. Is it true that $3,320.17 is the balance that's owed on this account?
Yes, sir.
Thank you. Sir, is there any other reason why you don't think you owe that money?
Oh, yeah.
Because I'm about ready to rule.
I thought I was supposed to get a jury trial.
No. I set this for trial sometime back in December, actually.
So you waived it for a non-jury trial. Oh,
Sir, you gave no objection nor requested a jury trial. So
yeah, I gave no objection. Okay.
when I set the date on December 23rd, there was no objection to it. And because you had not requested a jury trial at any given point. So I'm not even going to get into that. You waived that right. Any other reason why you don't think you owe the money that's been testified to, sir?
Oh, Your Honor.
All right. Mr. Pantera, you forego closing argument.
Yes, Your Honor.
All right. Sir, anything else you want to say to the court?
So I have federal questions to appeal for higher court.
Yeah. As soon as I enter my judgment, you'll be able to appeal all you want, if you can perfect it. So the court, having heard the testimony in this case, the court would find that plaintiff has sustained their burden of showing that the defendant owes $3,320.17 in outstanding rent and charges on this account. And the court would order a judgment to the plaintiff in that amount plus its cost. That would constitute then the redemption amount on this premises. The defendant would have 10 days to pay that, which means he would have to pay that by February 24th, or a writ of restitution or order of eviction may issue. I will sign a judgment.
Should I show it to Mr. Loudon?
Show it to him if you'd like, or you present it to the court. I've issued my judgment. The court has signed that judgment. Thank you.
Well, guys, we have come to the end of both of these proceedings. And as we can see, once what we all knew, Judge Simpson definitely wasn't going to have any of the nonsense we saw in that first appearance. As soon as Mr. Lane started to go into his sovereign citizen script, Judge was like, nope, we're not even going to do this over Zoom. We'll just go ahead and do this in person. And, he ordered him to come in person, as we all saw. And, I was just kind of shocked. We have videos up here dealing with people that owe credit card debt. So we've heard some wild things, but just to see some of the things that Mr. Lane did and hear some of the things that he said, he owed $3,320, somewhere around there. And for him to have gotten assistance in paying his rent at one point and then turning around and suing the place for money that he never even paid him, yeah, it was definitely pretty wild. And then the hoops that Judge Simpson had to jump through just to get him to admit that he even lived at the address, it was just all crazy. But yeah, that was pretty wild. I've heard some wild stuff with people that owe, on their credit card, sovereign citizens that owed on their credit card. But this by far was some of the wildest things that I've heard. The whole, the United States haven't had money since 1933. This money is money that I have as credit in the U.S. Treasury. Yeah, it was just a bit much. But as we can see, like all of us knew before it got to the end, he didn't have a leg to stand on. And Judge Simpson obviously rules in the favor of the plaintiff for the $3,320 and whatever, I think 17 cents that he owed him, which makes sense. But with that being said, it wasn't a whole lot to do commentary on this one. A lot of that was just wild and outrageous, outlandish, and it is what it is. So once again, guys, thank you for joining me for another Sovereign Citizen video. This is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. I appreciate you guys. Everything that you're doing, commenting, subscribing, it's been great. Thank you, thank you, thank you. And with that being said, God bless.
Looks like Ms. Walsh, are you going to be arguing this?
That's correct. Good afternoon, Your Honor.
Good afternoon. I think I see a Jeffrey Lawrence.
Jeffrey-Lawrence, Cowgill, beneficiary.
This case involves a defaulted vehicle loan for a recreational travel trailer. Defendants executed and entered into a retail installment contract with the dealer. The last payment made on the loan account was on or about December 28th of 2021. The balance owing to plaintiff is the principal sum of $35,928.21 plus late fees in the amount of $53.88 plus accrued interest in the amount of $1,325.37. While they have submitted many pages of inadmissible hearsay, including excerpts from several books and alleged excerpts of statutes and constitutional provisions and postal tracking information and other materials, documents that appear to have been drafted by defendants themselves that have names like conditional acceptance or a bill of exchange or a declaration of the Naturalization Act of July 1779 for Jeffrey L. Cowgill status correction to the land and soil jurisdiction, not sea admiralty. They elaborate on the allegations that the credit union rejected payment that defendants allegedly made by submitting a form 1099A, like an IRS form, and a promissory note. But those forms of alleged payment are not legal tender, and the credit union was not obligated to accept them as forms of payment. Defendants also argue that they sent a bond coupon in the form of a promissory note to the credit union as an attempted tender of payment under the contract. However, defendants have not submitted any admissible evidence to support that proposition. And even if they had, that is not a valid form of payment. So the plaintiff asks that the court enter the revised proposed order granting summary judgment to plaintiff.
Mr. Cowgill, I did, just so you're aware, I did read through your response and attachments. So if you have, I'd like to hear what argument you have in response to counsel.
Without prejudice, I, Jeffrey Lawrence Cowgill, with Teresa Ann Cowgill, the beneficiaries, make a special appearance sui juris propria persona under fraud, menace, and duress before fiduciary Bashor. This is a Sesticate trust action, which you are now a real party in interest to. I'm the living, breathing man on the land and soil. The dead entity, all caps, Jeffrey Lawrence Cowgill, was expatriated, and I, the living man, have an unrebutted UCC-1 lien and security agreement with the all caps entity, and Gary Bashor serves as the entity trustee in a fiduciary capacity. Virginia law further provides to authorize such filing, the debtor must do so in an authenticated record by authenticating or becoming bound as a debtor by a security agreement, or 3, by acquiring collateral. I have supplied that to you, that there's a UCC-1 claim. The plaintiff's agents are outlandish, stating Federal Reserve published documents are hearsay. Statutes and constitutions are admissible under 56B, as it states. The defendant may move with or without supporting affidavits for a summary judgment in such party's favor as to all or any part thereof. Since the plaintiffs have violated RCWs, UCCs, and U.S. codes, among other laws, these laws are fact and admissible per CR 56B. The plaintiff says the conditional acceptance is a nonsensical document, yet it is in Black's Law Dictionary under conditional acceptance. The definition is an engagement to pay the draft or accept the offer on the happening of a condition. A conditional acceptance is in effect a statement that the offeree is willing to enter into a bargain differing from some respects from the proposed or the original offer. The conditional acceptance is therefore in and of itself a counteroffer. We conditionally accepted the offer of the plaintiff, but the plaintiff ignored us, knowing that the conditional acceptance stated acquiescence would void the original contract. The postal tracking combined with the Esquire Scroggins letter is fact and evidence to the plaintiff receiving the bills of exchange that they did not return. The plaintiff's agent, Esquire Bertolino, admitted they received them as well. What qualifications does any of the plaintiff's agents have to declare what is and is not a bill of exchange? Since the plaintiff's agents, the Esquires, lied about the redacting and have submitted evident affidavits that they are not qualified to submit, how can their words be trusted? They are not bankers, nor is Mr. Howard. What is his qualifications to make such declarations? He looks at a piece of paper, the plaintiff's agents hand him, and he takes it as gold. I have people at work that know federal and state policies and procedures, but they're clueless as to what those policies and procedures are for. How can Mr. Howard be trusted acting as an entity's agent? No offense, lawyers lie all the time. Fact, Agent Howard produced a terrible photocopy that has a signature on it for the dealership that is not on our copy. Who signed the contract? Can the plaintiff's agents prove that an authorized representative for the dealership that is delegated by the plaintiff signed that contract? The plaintiff wants to rely solely on the contract, so let's talk about the contract. Who signed it for the dealership? Why hasn't the plaintiff gotten an affidavit from the dealership? Because they don't know who signed it. Washington rule does state that the photocopy can be used in the original's place unless there's genuine question of the original. And that alone poses a major question. Where is the original? Is a signature on the original more legible? Is there any other evidential factors on the original that can give us the answers to that truth? On the UCC, we did tender for payment bills of exchange, who the plaintiff's agents are not qualified to decide with their opinion What is and is not a bill of exchange? And as for where the bills of exchange are, ask the plaintiff. What did they do with them? They did not send them back. What did they do with them if not monetize them for gain? Esquire Bertolino states that the instructions on the 1099-A state tangible property is not included, yet the exact wording is no reporting is required, meaning you don't have to, but you can. It does not say no tangible property, so Esquire Bertolino lied. The plaintiff has violated many UCCs, U.S. codes, not just 12 U.S.C. 5511B2, C codes and definitions on everything that the plaintiff has violated, and I have proven the facts. Why didn't the plaintiff return the documents they say are not bills of exchange with an explanation or dishonor? Why wait and have Esquire type up some bunk letter and still not return those bills of exchange? When you're doing something and you find out that there's fraud or some shenanigans going on, you stop. That would explain why we made payments until we found out that there was fraud. Payments in fiat currency were being made until we discovered the truth and the plaintiff's agents violated laws and codes. All they had to do is return the bills of exchange with dishonor and or validate the debt or answer the conditional acceptance. Instead, they ignored us. That's why we're here. The Federal Reserve publications, like Hearing the Truth from the Horse's Mouth, state exactly how banks operate. How is that not fact? The Federal Reserve dictates what the banks can and cannot do. I'd say their publications are not only admissible, but damning to the plaintiff's complaint. As the plaintiff, they have to prove their complaint, and not only are there holes in their contract theory because of the signature, but it begs the question, why are they dismissing the UCC, which all banks and courts are bound to? And why didn't they rebut the UCC one? And as for the Leach Act, I submitted the copy to the court from the plaintiffs behind a sealed financial record. There's no explanation for these agents or their office to be passing around sensitive information that the agents do not need. So they did violate the act. What is their confidential material protocol? Who has seen the documents and where is it stored? How was it sent to the plaintiff's agents? By mail, fax, email? So how can you tell me it was secured when they didn't take the precaution when they sent it to me in regular mail, not certified? The plaintiff never asked if they could share our personal information of that magnitude. This alone sets forth facts to either dismiss or send this complaint to trial so the plaintiff's agents can be questioned. Put the qualified bankers on stand so we can find the truth. The plaintiff's esquires are not qualified to speak on the plaintiff's behalf. Mr. Howard is not a banker, so neither is he. I sent, and if you use it without prejudice, like I have, a 1099-A can be anything I want. I can write a bill of exchange on a blank piece of paper. It's what they do with it. They didn't send it back with dishonor. They didn't send it back at all. All they said is, well, now we're going to limit how you can and cannot pay. And so they violated the UCC. And with that, I'm done.
Any brief response?
Thank you, Your Honor. The retail installment contract expressly provides that the borrower the borrower agrees to pay the amount financed and the finance charge in U.S. funds according to the payment schedule below, as explained on section 1 on the back. That's at Exhibit 1, page 2. It's undisputed that the defendants did not do so, that they defaulted under the terms of the contract. They don't dispute that they received the trailer. They don't dispute that they received this loan. They don't dispute that they made payments under this contract. They knew how to make payments under this contract. And they don't deny that they stopped making those monthly payments. There is no genuine issue of material fact that they entered into the contract, that they defaulted under the terms of the loan, and that they owe the amounts set forth in the Howard Declaration. It's, not appropriate for defendants to malign attorneys generally, or my colleague, Ms. Bertolino, in this court, with no evidence, no admissible evidence that would support any of the allegations that defendants have stated here today. There is no demonstration, no allegations, no demonstration of fraud by the credit union or by anyone. There is no, defendants just simply have not created a genuine issue of material fact regarding the credit union's claim for breach of contract or its entitlement to replevin in this case. And that is, those are the plain facts.
So I got one question I have, which is not necessarily germane to my decision. Does your client still have the bills of exchange that were submitted?
That I don't have an answer for you today.
Your Honor, I've asked for them back and they just blatantly ignore me.
All right. Well, when I look through this, I mean, there's a lot of interesting theories that are kind of flowing all through this. What it boils down to, from what I gather, and it seems to be undisputed, is you folks went in, you bought a trailer on time, agreeing to make payments of some amount, pay it off. At some point in time, there was an issue arose where you decided to do something different, and then no more payments were made. There were some submissions of bills of exchange as an attempt to make a payment, as well as a 1099 as an attempt to make a payment. And I guess my answer to that is those probably would not be something you could walk into Safeway and buy a banana with, because it wouldn't be considered regular money for purposes of buying things in a retail situation. They may work in a UCC type thing or something like that. This is simply a consumer contract to buy a trailer and make payments on it. And when you're all done, you get the title. The credit union, it appears without any objection, has a security interest, which is indicated in the title as the legal owner. And I've not heard, I mean, there may be some other claims, but that you may have against them. I'm not making an assessment of that, because even if you did, it would not upset the contract to buy the trailer. So, I mean, you buy the trailer, you got to make the payments, you make the payments, they get the trailer back. So I am going to grant the motion for summary judgment. In doing so, I want to just give you some guidance, sir. What will ultimately happen is they get the trailer back and then they sell the trailer to somebody else. They apply the funds they get from that against the bill that's still owing. So the more money they get out of that trailer, the less money you end up having a judgment for. Does that make sense? So it's in your best interest not to do anything to the trailer. It's probably in your best interest to hook it up and drive it down to the credit union, because that would save some costs.
Oh yeah, I don't have a truck to do that, so they can come get it.
Oh, okay. I'm just trying to point out it's.
And so my copy of the contract not having a signature from the dealership doesn't matter.
It really doesn't.
And you being the trustee in this case doesn't matter.
Well, I'm not a trustee, sir. I'm a judge.
You are, because I appointed you one. As the beneficiary, because I'm not to do that.
Okay, I'm not able to accept that as a Superior Court judge.
What about them just putting out our social security numbers without our say so? Like, they could have completely ruined our credit. Someone could have those numbers and be doing damage to us right now.
Well, if those were passed to the attorneys as part of the collection, then that would be something that would be allowed. If that was sent out beyond that, obviously that's a separate issue. And if in fact that were a claim that were proven, there may be something there. But again, that doesn't affect the contract. Those are all other claims that you may have. I'm not saying you do or you don't, because I don't know enough about those. even based on all the information that you filed. You filed, and I read through all the stuff you filed because it's what I do when I do my job. So,
So can we have those forms of payment back?
I
Can
would,
you order them to return those to us?
well, I think it's appropriate if there's some value in those, those should be returned to
There's a lot of value in them if they still have them. And if they don't have them, then
Then what happens if they don't return them?
Well, honestly, guys, I don't think he'll ever know because I don't think he or his wife are getting those forms of payment back because more than likely they weren't worth anything, even though it was to them. But we've come to the end of another proceeding. I'm not even going to go hard on the commentary on this one. We heard what Judge Bashor had to say. He gave the summary judgment to the plaintiff. We see Mr. Lawrence just trying not to be responsible for something that he obviously signed up for. And not only did he sign up for it, but he was making payments on it, and he now still owes $36,000. You see, he got mad and said, listen, I'm not going to bring it to them. They can come and get it, even though Judge Bashor is trying to say, listen, if you just go ahead and get it back there, you already lost. At least you can save yourself some money. But with that being said, guys, thank you, as always, for joining me for another Sovereign Citizens Hall of Fame. Don't forget to like, subscribe, and share. It is much appreciated. And with that being said, guys, this is Sovereign Citizens Court. And for now, Sovereign Citizens Court is adjourned. Thank you, guys, and God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.